Hi, my name is Lorenzo Azar Banks, here on behalf of Minority Report Law Office here in Oklahoma City. And today I'm doing another video response to a question that we had posted to our Facebook page. And this is probably one of the more common and fun questions that we get to answer, so I'm excited about doing this video. The question goes something like this. I'm a musical artist, and I have songs that I've created that I haven't registered with the U.S. Copyright Office. And I'm afraid that while they're unregistered, someone's going to take the songs from me. Do I still own the music that I've created even though it's unregistered? Yeah. Federal law says that despite the fact that you haven't registered your music, you are still the legal owner of the music, and you are the owner of all the rights to that music. Didn't see it coming, did you? Well, let's learn a little bit more about copyright law. The United States Constitution says that the U.S. Congress is solely responsible for creating the laws that govern copyright here in the United States. And when Congress created those laws, they put specific language in the legislation. They said, and I'm just paraphrasing, that copyright protection should cover any original works in music and any words that accompany that music. And that copyright protection should subsist when the work is placed in any tangible medium. Now, that is just a fancy way of saying this. When you write the words down to your music, when you write out the sheet music, when you record the song or make a video of the music, because you're taking your work and putting it in a tangible medium, in some form that can be reproduced, it can be copied, your copyright protection is automatic. There's no need to do anything extra. Copyright protection is there from the moment of creation in a tangible medium. Pretty sweet, huh? It gets better. Because Congress also included in the legislation that copyright protection will last for the entirety of the author's lifetime, and then 70 years after the author's death. So you've got this long period where copyright protection is going to protect you, and there is no registration requirement. And remember, with this automatic copyright protection being there, you are going to have certain rights to your music, exclusive rights to your music, and you will be able to dictate how people use, copy, perform, or otherwise distribute your music. And in certain instances, you will be able to be paid royalties for such. So you have to love U.S. copyright law, protecting you even though you haven't taken the time to register your music. Now, there is a caveat, but we'll get to that later on here in the video. So some things we want to take away from this video. We hear people say that to get a free and quick copyright on your music, all you got to do is place your music in an envelope and mail it to yourself. No. Remember, we read the statute. Your copyright protection in your music is automatic once you place it in some tangible medium. So putting your music in an envelope and mailing it to yourself doesn't give you any extra copyright protection. Mailing your music to yourself is what we know as the poor man's copyright, and it is a myth, and it's unnecessary to protect yourself. Here's where I believe the myth came from. Artists before computers were having a hard time being able to prove when they created their music. So what they would do is they'd mail the music to themselves and use the postmark on the letterhead, on the envelope, to show when the music was created. The problem with that method is that that postmark does prove when the letter was mailed, but it doesn't do anything to prove when the music was created inside the letter was created. So it's unnecessary, and there are other avenues to prove when your music was created. Remember, this is the 21st century, and so when you create your music, more than likely on a computer, whatever program you're using is going to have a timestamp attached to the file that you export. So I don't care whether you're using Pro Tools, Fruity Loops, Acid, Reason, whatever your production program is, it's going to have a timestamp on the file that you export, and it should be fairly simple to prove when your song, when your music was created. Keep that in mind. Poor man's copyright, unnecessary. And you're also going to hear people say this, well, copyright protection is automatic, so I don't need to register my music with the Copyright Office. It's true, it is automatic. You don't have to register with the Copyright Office, but there are benefits. Remember the caveat I said at the beginning of this video? Here's the caveat. U.S. law says that before you can bring a lawsuit for copyright infringement, you have to have registered your music with the Copyright Office first. Now, don't panic if you haven't registered your music with the Copyright Office and someone begins infringing on your copyright. It's okay. All this is saying is before you can bring that lawsuit, calmly go down and register your music with the U.S. Copyright Office. And then after you've registered it, then you can file suit for copyright infringement. Remember, just because you haven't registered doesn't mean that you've lost the rights to the song. It just means that you have to go through certain steps first, i.e., registering your music with the Copyright Office before you can file a copyright infringement suit. Not only does it make sense to register your music, it also makes sense to register your music in a timely fashion. See, because if you do have to bring a copyright infringement suit, U.S. law says this, is that if you register your music within 3 months of the date of first publication, you will be able to get extra damages in a lawsuit for copyright infringement, in particular, statutory damages and attorney's fees. Statutory damages are damages that are listed within the statute. And if you don't have the opportunity to get statutory damages, you would have to prove actual damages, such as loss of profits, which can be proven, it's just harder to prove than the statutory damages that are going to be listed within the statute. You don't have to prove those, you just have to show copyright infringement. And of course, being able to recoup attorney's fees is always a good thing for you. Now, take in mind, this is coming from an attorney. But you have to have registered your music within 3 months of the date of first publication to get these benefits. Got it? Good. Once again, my name is Lorenzo Azar Banks here on behalf of Minority Report Law. You can reach us at minorityreportlaw.com, or you can catch us on our Facebook page at facebook.com/MRLawOffice. Post your questions there and like us so that you can keep up with the videos that we're posting. So get out there, create your music, share your creativity with the world, and rest assured that your creativity will be protected by federal law. See you next time.